Well, welcome everyone to tonight's asset protection webinar. This is from Protect Wealth Academy. We've been teaching this same type of webinar for over 10 years. We're delighted to have you on. And this is a topic that we keep coming back to, but it's really the foundation of which all estates plans start. I get people all the time on our hotline that will call in and say, "Oh, okay, I need to set up a limited partnership or I need to set up an LLC." And I'm going, "Okay, well, let's talk about the overall plan and what is it you're trying to protect, and do you have an estate plan, and how are we going to tie this all together?" And and for me, it's critical that somebody understands the overall and not just sets up one little business, because it might be not exactly what they need, and everything has to be tied to an estate plan. So very, very happy to have John Anderson. He's the head of Anderson Business Advisors Estate Planning Division. And I'll introduce him in just a minute. Let me go through a couple quick little announcements first. Again, this is part of a huge webinar series that we've been teaching for years. And we've had some incredible attorneys on and presenters. Clint Coons, we've had Toby Mathis over the years, we've had Michael Bowman over the years from the Anderson Business Advisors, but we also had some best stock market people that we can find, the best real estate people we can buy. Coming up in 2 weeks, or I guess next week, um, it's a topic that we've played around with, but we've never really invited on our stage. I'm really excited about dispute mediation and arbitration to avoid lawsuits. We talk about lawsuits and how to protect ourselves, but rarely have we talked about the mediation that could go on before to avoid lawsuits. So excited to have Steve Sumption with us next week. And then the following week will be cost segregation. And those of you that don't really understand that but have real estate, oh my gosh, there's so much we can do to reduce your taxes, give you bigger depreciation deductions this year, which gives you more money to invest. And so we wanted to explore that. And so that's sort of where we're at in the schedule. If you'd like recordings of any of the webinars that we've done, go to YouTube and see the little circle here on your screen. Go to YouTube, type that in. Most of you know how to do that. And then type in Protect Wealth Academy. As soon as you do, this screen right here will show up. Hit subscribe, and that gives you a whole plethora of webinars, trainings that we've done over the years. Anyway, so Protect Wealth, or go to YouTube, Protect Wealth Academy, and then hit subscribe, and you'll have access to all those things that we've done. We've got some amazing summits coming up. Um, the closest one to you is June 14th through 16th. When we do a summit, then that's a live stream event. Then we'll do a live event in Orlando. We're really excited about that. The hotel just opened up and is booking reservations. If you will register for that live event, if you're planning on coming, register with us. We'll immediately send you a link for a discounted rate at the hotel. I think we've got an incredible value. It's a Disney property or on Disneyland at an Omni hotel for only $129 a night. It's an amazing deal. So we negotiated really hard for our students. And so that's coming up. There'll be a live stream event in October. And then in November, we'll be back in Vegas. We're not taking reservations for that one yet, but know that that's on the calendar. When we do our summits, we are bringing the best of the best of the best attorneys in the nation that we can find. The best in stock market, the best in real estate, the best in mindset. Um, we're bringing some incredible people. Bill Danko, most of you will recognize him as the co-author of The Millionaire Next Door. He's been on the last 4 or 5 summits. We've got Kwame Granderson, an amazing attorney that has raised over $1 billion in venture capital. We've got I don't want to go through the whole lineup, but it's an impressive group, and we're delighted to have them on our stage. Please, if you have not ever taken time for a 3-day summit, make sure you do that. Take a look at the 200 plus Google reviews and the 250 plus Facebook reviews, and let the students tell you about our summits rather than us. But anyway, there's that. If you'd like to see a copy of the agenda, you'll find out that it's not a wussy little 3-day class. We cover a lot of ground, and and in a way that I think most of our students walk away going, "Oh, I get it now. I understand how this all ties together." And so if you haven't had a chance to do that, you can register at protectwealth.com. There's a lot of information about the summit, but that's where you would go to register. And then every Thursday, there's a Facebook with Don. I take your questions live. And so if that's helpful for you, anybody. And then finally, before we turn the time over to John, I wanted to give kind of a quick little disclaimer. What we talk about on these summits, in our webinars, we can teach general principles, how they apply to you and your situation. That may differ. It may not, everything maybe that we talk about here doesn't apply to you. Some of it does, and we certainly can't get to everything. But that's why we give invitations to meet with our attorneys, our specialists individually, or meet with your own accountants, meet with your own attorney. But don't take every concept that we teach for face value and say this applies to me, because sometimes it doesn't. We want you to meet with attorneys. We want you to consult, but we also want you to understand the basic principles that underline everything that we do. And so with that, let me kind of introduce the topic of estate planning a little bit. I've had over the 20 something years we've run an asset protection hotline, answered tens of thousands of questions from our students. And I think one of the biggest problems that we face is we set up legal structures and we talk about black boxes and circles and we draw arrows back and forth. But our students, if they don't really understand the concepts, if you really don't understand what a trust will do or what a will do, our students are very hesitant about putting, well, this is my bank account, this is my brokerage account, this is my house. I can't put that into the trust because they don't understand it. And I get that. We are apprehensive about placing assets into entities that we control until we understand it. And then when we see the value, when we see what it does to our taxes, maybe to lower taxes, maybe have no impact on our taxes at all. When we see the transfer of wealth, when we see the protection that we get, once the understanding comes, then our students are very, very anxious to transfer assets because they understand. But until that understanding comes, I understand the hesitancy, and thus the need for this webinar tonight. John, we're excited to meet with him. John's been an attorney for, John, how long have you been practicing now? Close to 20 years?
Yeah, I look that old.
All right. Well, over 10. How's that?
Over 10, yeah.
And we're delighted to have him because of a very easy to understand. I've known Clint and Anderson Law Group and Toby and Michael for really 20 something years. John is fairly new to the organization, but brings a whole bunch of experience in estate planning, but also in explaining things to normal individuals that maybe just need a little understanding. John, I'm delighted to have you on tonight. I'm going to turn the time over to you. I've walked through your slides. I'm excited about what you're going to be teaching our students. And then how do you want to do this? Do you want to answer questions as we go through, or do you want to go ahead and present and then I'll read the questions when we get all done? Would that be easier for you?
Either way will work fine with me. I'm good with answering questions as they come in if you want. So maybe if we go through a slide and somebody has questions about it before I go to the next slide, we can go ahead and address those questions at that time.
That'd be great. And if we miss anything, we'll pick them up at the end.
Yep, sounds good.
All right, John, thank you for being on. Turn the time over to you. Do you know how to turn your screen on there?
Yep, let me.
We're not just talking wealth transfers tonight. We're talking screen transfers. There we go. Now we can see.
We're good?
Yep.
Okay.
Thank you.
All right. So when most people think of estate planning, a lot of times they think of something in the future or something that doesn't really apply, or hey, they'll be dead, who cares? They don't have to deal with it. And so the problem with that idea of thinking is that when you think of it like that, it limits the possibilities of what you can do to kind of create a legacy after you're gone. And so when we create an estate plan, it's not just about what you're going to give your kids. It's about what goals do you have for your kids? What do you want your kids to achieve? What do you want your grandkids to achieve? And how can you facilitate their ability to actually achieve those different goals that you have for them, even if you're still not around? And so we're going to talk about some of the different methods that we can use to be able to do that, and being able to do it in a way that keeps it private within the family. So we're not involving, the courts, we're not involving the general public, and also in a way that's more secure, less likely to be challenged down the line. So just to begin with, two quick examples of estate planning. Both of these are Las Vegas big boys. We've got Howard Hughes and Frank Sinatra. So with Howard Hughes, he died in 1976. He died without doing any estate planning. Now, that's questioned. If you want to look into it more, there's some interesting books about whether there was a will that was valid. But to the court's eyes, there was no will, there was no trust, nothing was done. And so from 1976 to 2010, his estate was in the probate court, 34 years. And by the time everything was finished in 2010, most of the money had either gone to the government in taxes or had gone to the lawyers. 34 years of legal fees will pretty much drain most of an account. So on the other side, you have Frank Sinatra. He died with both a will and a trust. So some of the assets went through his will, and we do know those because they went through probate. But all of the assets that went through his trust, which was the majority of his estate, we have no idea where those assets went because it's private. And as far as we know, his family has it, and they're doing whatever they want with it, and it's none of our business. So those are two extreme examples of where an estate plan works and an estate plan or not doing estate planning created an absolute disaster. Now, if you don't do an estate plan, are you going to be Howard Hughes? Probably not, but it's not uncommon for someone to be in probate without an estate plan for 2, 3, 5 years, and having the courts tie that up for that period of time. So some of the different ways in which we can do estate planning. I'm just going to go through just this quick chart here, and then we'll go through each of them individually in more detail in the next few slides. So don't feel like you have to understand all of these right now. So the basic one is intestate succession, or basically that means you died without any type of estate planning. No will, no trust, none of these things were done. If that happens, then you have to go through probate. You have no ability to determine if there's any kind of tax planning. if there's going to be estate taxes or not. There's no privacy because it's all laid out in the court records, and you have no control over the distributions. If you die intestate, each state has their own succession rules that have to be followed of who the money goes to, and it's probably not who you want it to go to. With a will, on the other hand, a will is just a directions given to the court as to what you want the court to do. And so the court will take your will and they will try to follow it as best they can, although they're not obligated to, and they will distribute your assets. It's all in the public record, and it can be very time consuming and very expensive, and we'll talk about that a little bit more. Another one is beneficiary designations. So this is where you would say, like on, for example, life insurance. When you set up a life insurance policy, you set up a beneficiary designation as to who's going to get paid that life insurance policy when you pass away. And you can do these designations on more than just, life insurance or a retirement plan, 401k or IRA. You can actually do it with property in some states. Not all states, but some states allow you to set up what's called a beneficiary deed or a ladybird deed or transfer on death deed, where when you pass away, the property will automatically pass to the person you've outlined as the beneficiary on that deed. And you can do it on bank accounts as well. So this type of planning, yes, it will avoid probate, but there's certain limitations to it that we'll go over that may not be what you want to actually happen. Another one is joint tenancy, where, for example, you've got a piece of property, you want it to go to your son, so you list your son as a joint owner with rights of survivorship. On a new deed, you have that recorded. So when you pass away, it automatically passes to your son. Again, this avoids probate. Seems pretty good. But again, there's going to be limitations on this that are kind of scary. I would not advise someone to do joint tenancy with rights of survivorship on any piece of property other than with his spouse, because it can cause some serious issues, and I've seen it cause some major issues. And then the final one that we'll talk about is using a trust, specifically a living revocable trust is your typical trust that's used for estate planning. And with that, you can avoid probate. You can do advanced tax planning. It's all going to be kept private, and you get to have a lot of control over how the distributions are made to your heirs. And we'll talk about, so going through each of these let's talk about probate. So with a will and intestate succession, you go through probate. So what is probate? Probate is just Latin for proof. Prove it, right? And so you've got to prove that the will is valid if you're probating a will. You've got to prove that there's no creditors, or that the creditors are being have been notified and are being taken care of. You have to prove what assets there are. You have to prove that who the beneficiaries are, and that they're the correct beneficiaries according to the will or according to intestate succession. You have to prove all of these different things to the court before they're going to authorize the actual distribution of the assets. And so with a lot of attorneys that do estate planning, they will give you a will, and it'll be fairly cheap. They only charge you a couple $100 for it. And the reason why they do that is because they know that later on, after you pass away, your family is going to have to come back to them to probate the estate, because they're not going to be able to do it on their own. And so when the family comes back to them to probate the estate, that's when the lawyer gets his money. Right, he's got his money in his pocket from writing the will for you, and then he's going to collect another fee when he probates the estate, and the fees can be pretty hefty. Oftentimes, they're based off the percentage of assets going through probate, and they can be upwards of $10,000, $15,000 easily, even on a small estate. And the other problem with probate is it is a part of the public record. Anything that gets filed in the probate court is public. People can go and search it. In fact, I knew a guy that that's how he did real estate, and that's how he found his leads. He would go and search the probate record. He would find these families that have real estate, and then he would go and contact the families directly to try and get them to sell the property to them or to him, so that he could usually fix them up, because they were usually old and dilapidated, and then flip them for a profit. And he actually did pretty good. I don't know if that's, maybe you could use that in your own business, but I don't think you want your family being contacted by these type of people trying to swindle them out of real estate that they may own. And so it's always good if we can avoid probate, so that we're not getting this type of information out there of what assets you have, so that someone else can come in and try and take it from your family. The thing you got to remember is, when someone passes away, usually the family's in a compromised situation emotionally. And it is very common for these types of people to be able to come in and influence them, or to get assets from them in these types of situations. So it's always good to avoid probate. So we don't want to die intestate, because that's probate, and we don't want to just use a will, because a will has to be probated. And so we may want to try and use some other methods. So any questions there, Don?
Sorry, couldn't find the mute button there. There's a couple questions, a little unrelated, but
Okay.
Tony says he's setting up a trust. When he buys an investment property, should it go in the trust, or should he buy it personally in his own name?
If it's an investment property, I would want it bought into an LLC if at all possible. If it is not possible to purchase it in an LLC, then a trust would be better than putting it in your own name.
But he might have to have it in his own name,
right,
or in the trust to get financing, and then it could be conveyed into an LLC often
later.
after.
Yeah.
Right?
If you're working with a financer, if you're working with a lender, a lot of times they're going to require that it be purchased in your own personal name. And you wouldn't even be able to purchase it in the name of the trust even. So if that is the situation, you're probably gonna have to purchase it in your own name. Then you can get it transferred into an LLC, and then have that LLC ownership flow through to the living trust.
So the Tony, your question is good, because the limited partnership, or I'm sorry, in the LLC gives it asset protection. The trust is really a probate tool, but during the 3-day summit, we're going to show you how these all interact together, and how the trust, your ownership of the LLC now flows into the trust. All right. Maria, do I need to be wealthy to set up a trust? Good question.
Yeah, I get this all the time. No, you do not need to be wealthy to set up a trust. Anybody who owns real estate should have a trust. Because the trust itself, they're not expensive. Well, compared to probate, a trust is extremely cheap. And so if you have any type of real estate, even just a personal residence, you should have a trust, so that you're not having to probate that property after you pass away.
I've heard that the national average is usually 6 to 10% of your overall estate to probate an estate. So if you got $1 million estate and it's going to take 6% of that, that's $60,000, or you could pay a couple $1,000s and have your trust created. It seems to make a whole bunch of sense to have the trust. Question: Do I need a will and a trust, or is just the trust alone sufficient?
So we will address that, and the answer is yes. You need both.
Okay, good. And what do you consider to be a small estate? Under 100,000, or is it relative, or I don't know.
So it is relative. A small estate I probably would define as anything under 500,000. And even then you still want to trust. Like I said, if you have real estate, you probably want to trust. So yeah, there are some laws that are called what are called small estates. Under each state has their own limit on it, and they vary from state to state. Those types of estates, usually it's under like 100,000 in some states, it's 150 in others. Some of them are 50,000. Those types of estates you can avoid not going to probate through, just simply by using what's called a small estate affidavit. But those are not typically very common. It's not, you would be surprised at how much you're worth dead versus alive. And it's usually quite a bit more than you think. So I probably wouldn't rely on those small estate laws, even if you think you have one of those, just because there's a high likelihood that you're not going to qualify under those small estate laws.
Yeah, and we've done some research on that. Some of those, there's a couple states that any estate under $5,000 they don't want to deal with.
Yeah.
Well, that's a really low limit.
Yeah.
Yeah.
And most of them also say that anything, if there's any real estate, period, you can't do it.
Good.
The exception is California, but it's like $125,000 worth of real estate. 125,000, which yeah, show me a property in California that's not worth more than 125,000. So
okay, so there's a lot of I've read your let's go on and proceed, because I think it'll answer a lot of the upcoming questions.
Okay, so the next method, beneficiary designations. So with certain assets, this is the only way to pass them. Like I said, with life insurance, IRAs, 401ks, those types of retirement plans, the only way to pass those is by using a beneficiary designation. And we can use that in connection with the trust, which can help a lot with some of the problems that we have with beneficiary designations. I'll tell you a quick story. I had a client, he didn't want to do a trust. He just wanted to do beneficiary designations. So, he put it on his bank accounts. He did a beneficiary deed. He covered all of his assets. He had beneficiary designations on all of them. He passes away. It goes split between the kids. Sounds great. He didn't have to go through probate. It was super simple for the kids. Then the problem was that there wasn't any kind of centralized management. This guy had a bunch of kids. Everybody got their piece and went their merry way. The thing about when he passed away is there were still taxes that had to be filed. He had made money before he passed away. He had to file an income tax return. Nobody was in charge. Nobody did that. The IRS is not known for their punctuality. And also, if you do not file a tax return, your statute of limitations does not start running. So this went for several years. And every year that it's not being filed, it incurs extra fees, extra interest, all these penalties that get added onto it. And finally, the IRS got around to auditing this. Just for a simple 1040, if it had just been filed, it wasn't really that much money. But by the time the IRS got around to it, it had ballooned into this huge, massive tax bill. And the IRS gets to follow the money. They got to follow each of the different lines to each of the different kids to go and collect all the money for this huge tax bill, simply because there was nobody in charge to make sure that everything was taken care of before the distributions were all made out to the beneficiaries. So that's one of the problems we have with a beneficiary designation, is it doesn't have centralized management. It doesn't have someone in charge who's going to make sure that everything gets taken care of before we start making distributions out. Another thing is, if you use a beneficiary deed, that is public information because it's recorded on the deed. So the beneficiaries that you're having the property go to are public information there. And so it's not exactly private. I also had a client who used the beneficiary designation. He said, okay, I'm going to give it all to one kid, and then I'll just have that kid split it up between, my other kids. And so he's got centralized control there. You can guess what happened. The kid didn't split it, and there's no legal obligation for them to split it. It was given to them. They can do whatever they want with it. So beneficiary designations, they have their places and they are useful in certain situations, but I wouldn't rely on them to take care of all of your estate planning needs. Okay. Another one is joint tenancy, adding the kid onto the deed so that he has rights of survivorship. When you pass away, it goes to the kid. Problem with this is when you put that kid on the deed, that kid is technically a 100% owner of that property. If your kid goes bad, has creditors coming after him, then your property has just become subject to your kid's creditors. And I've seen plenty of situations where this has happened, where mom and dad lose their house because, Jane decided to do a risky flip and end up losing her shirt. And they come back after the house that mom and dad have because Jane doesn't have anything. She lost everything. And so they come back after the parents' home because it's in her name as well. The other thing that you lose out with a joint tenancy is step up in basis. So step up in basis is where, you buy a house for $100,000, right? And then you sell it for $200,000. So your capital gains is that difference between $100,000, which is your basis, and the $200,000 that you sold it for, right? So you have $100,000 of gains. That's what you pay your taxes on. When you pass away, your property or all your assets get a step up in basis to the full market value on the day you passed away. So if you bought a property for $100,000, you passed away, and then your kids immediately sold it for $200,000, that basis is $200,000. There's no capital gains. If you use joint tenancy with rights of survivorship, you gift them the property at the value, at the original basis that you bought it at. They don't inherit it. They do not get a step up in basis. And so you're actually setting yourself up for a huge tax bill in the future if you use joint tenancy. And so why do we want to use a living trust? A living trust, like we said, avoids probate when done correctly. Now, I've got to put that caveat on there, when done correctly. I have seen plenty of trusts that do not avoid probate. And the reason why is because they were not funded. If you had a lawyer who drafted up your trust and did not teach you about funding, then you just have a will. And so what is funding? We're going to use Don as an example here. So Don is going to be a super nice guy, and he is going to create a will, and he is going to give me his bank account. And then he's going to be even nicer, and he's going to die. So I go into the bank. I've got his will. I've got his death certificate. Hey, you're a nice guy. And I go into the bank and I say, hey, bank, here's his will. Here's his death certificate. I get the account. Give it to me. And what's the bank going to say? Yeah, go pound sand. Go get a court order from the probate court verifying and proving that this is his last will and testament, proving that you're the proper recipient of this asset. And then once you get that court order, come back and then we'll let you into the account. You got to go probate the estate, right? Well, let's say Don does the same thing, except for he does it with a trust, right? He writes a trust. He says, John gets the bank account, and then Don dies. I go into the bank. I say, hey, he created a trust. It says here that the bank account goes to me, and he's dead. See, here's his death certificate. What's the bank going to do? The bank's going to say exactly the same thing. They're going to say, yeah, go to court, get a court order, prove it, make sure that this trust was real, make sure that this trust is valid, and then come back. But if we fund the trust, Don actually goes into the bank while he's still alive and says, hey, I need to transfer this account from my name into the name of my trust that I've created. And they actually do the signature card, changing it from his name into the name of the trust. Then when I go into the bank knows that this trust exists. They've validated it already. And they can then verify my identity. The trust says that this bank account goes to me, and I can immediately get that bank account. Now, it's not exactly like that. It's your trustee or your successor trustee who's going to go in and do that. But we'll talk about that in a minute. But by doing that, we've avoided probate because the bank knows that there's this trust. And they know that when Don passes away, this is the person who's supposed to take over and take control. And so when I come in, I present my ID, I present the death certificate, hey, he's passed away. Then we automatically get into the account. There's no probate, there's no court, nothing, it's all done privately. No one else needs to know about it. And we've successfully used the living trust to avoid that probate. And then also, it's also more flexible. We'll talk about that, how we can use flexibility within the trust of how distributions are made to be able to achieve those goals you may have for your kids. And then it also allows for estate tax planning, which right now is not an issue, but we'll talk about how that may be an issue in the future. Do we want to do any quick questions, Don?
Yeah. Let's go through a couple questions. If I have a trust, then okay, we did that. Is a will used with personal property? A trust used for real estate and a will used for personal property, or what's the difference?
So we can use a trust for personal property, just like we use it for everything else. So I'll talk about it in a minute, but we can use a separate document. It's called a personal property memorandum, or sometimes the lawyers will call it like a Schedule B or something like that, where you can actually distribute out and designate how personal property is to be distributed, even with a trust. And it actually works a lot smoother than by using a will.
And sometimes we call it a personal memorandum or an appendix or whatever we call it. But this is where we say, look, we want the rose-colored china to go to Susie and the binoculars to go to Fred or whatever. But yes, that can very much be part of a trust. Good. If you have an investment property, mortgage lenders do not let you put into the LLC or into the trust. What do you suggest in this scenario?
So you can use a land trust to hold the property. Mortgage lenders may not allow you to transfer it into the trust, but there's a law, it's called the Garn-St. Germain Act, that says a transfer into a trust cannot trigger a due on sale clause. And so even though they may say they don't want to allow it, there's nothing that stops you from doing it. And so you can transfer the property into like a land trust to show that it's owned by a trust, and then you assign the beneficial interest, which is not public record, no one's going to know about it, into an LLC, so that the LLC, you get that LLC protection, or limited partnership, or whatever entity you're using to protect that asset as an investment property.
Good. Can a trust be the beneficiary of an insurance policy?
Yes, a trust can be a beneficiary of an insurance policy, and it actually can help, especially if you have minor children, because a life insurance policy will not pay out to a minor child.
And we see that done a lot with irrevocable life insurance trusts. And
Yeah.
absolutely. It's a good question. Do you put your personal property into a trust?
Yes, you want to have your personal property into a trust. Personal assets, if it's personal things around your home, a lot of times with the trust we draft, we just have a blanket statement that you sign that says, all my personal assets go into the trust and get distributed accordingly.
Okay. Is it better for a married couple to have a combined trust or to have one trust for each individual?
If we want to go for the optimal protection, two separate trusts. If you want to go for the practical answer, a joint trust usually works in most situations. There are a few, if it's a like a blended family, or where the husband and wife got married older in life, those types of situations, usually better to use a separate trust, and I would recommend it. But for someone who's been married for a long time, typically a joint trust is going to work just fine.
Yeah, there's what's called a Q-tip trust, where you're taking a combined married and saying this, it's really one trust, but it's creating three trusts within the trust. And
Right.
but very simply, the answer is it depends.
Yeah.
Sometimes we get people that marry late in life. They each have their own families, and keeping the assets separate is the optimal way to go. But the true answer is it really depends on their situation and what their goals are, doesn't it?
It does. Yeah.
I, I, all right. What is the cost to draw up a trust?
Are you talking about just Anderson or in general? It's going to vary a lot from attorney to attorney. I know some that charge $6,000 for a trust. I know some that charge $1,500 for a trust. Our price varies on the mood of the partners and whether they had to call a plumber that day. And so typically on the lower end, we're about 2,500 for your typical trust, but it'll vary between 2,500 and about 4,500.
But that trust, and when we teach the summit, I've got a slide that shows here's what a trust includes, which is all the ancillary documents that go with the trust, and the funding documents that go with it, and the wills and the powers of attorney. And there's a lot to creating a trust. It's not just one document. You put a lot of work into creating a trust for an individual, don't you?
Yeah, I mean it's a binder of papers about that thick. So if you need something to fall asleep to, just try reading it. But it's very thick and it's a lot of documents, but it's actually fairly simple to operate. So don't be intimidated when you see a big binder of documents and think, whoa, there's no way I can handle that. It's actually fairly simple to operate a trust. In fact, once you get it set up, you're not even going to notice it unless you want to make changes to it.
Brian is saying there are multiple types of trusts, and they all have different names, and the marketing companies get together and they come up with these unique, very flamboyant names for the trust. But they're really quite simple. What he's
Yeah.
saying, there's so many different types of trust. What specific kinds are we talking about here?
So for estate planning, for the most part, you're probably going to be dealing with a living revocable trust. I think that gets to this slide here. In legal terms, there's only two types of trusts. There's revocable and irrevocable. And when you hear about all these different other kinds of trusts, like an IDGT or a SLAT trust or an ILIT or constitutional trust, these or special needs trust or spendthrift trust, there's all these different names that are thrown out there. The question I always have is it revocable? Is it irrevocable? Okay, if it's revocable, I can write it in a way that it fits into these different terms. I can write it so that it has special needs provisions. I can write it so that it has spendthrift provisions. I can write it so that it has a lot of these things that are being marketed out there. but it's still just a revocable trust or it's an irrevocable trust. And so if someone is trying to get you into a particular type of trust, I would be very wary about that, because it's not the attorney's job to determine what you need it beforehand. It's the attorney's job to determine what you need based off of actually talking to you and figuring those things out. And so for the most part, most people are going to be using revocable trust. I'd say 95, 98% of my clients are dealing with revocable trust. We get into the irrevocable trust when we're dealing with state taxes, if you've got over $23 million, or in certain types of asset protection situations where we want to get a little bit more protection. And then for all these, other provisions, we can write these into the trust, and an attorney should know how to put those into the trust so that we're covering things like special needs. We're covering things like, if your spouse is not a citizen, what do we do? And those are their special provisions we need to put into that trust that cover that. So be careful with all the marketing out there. It is just that, it's marketing. It's not like, if you need an irrevocable life insurance trust that's written in a certain way to hold life insurance. A land trust is written in a certain way to hold that property, but I doesn't mean I can't include those types of things into an estate planning living trust.
Good answer. Okay, so let's go on with your presentation, and we'll answer a few more questions here in a few minutes.
Okay, so we talked about the revocable and irrevocable trust. Let's talk about the different players. So within a trust, you have three different players. You have the grantor, or sometimes they call it the settlor, the trustor. If it ends in OR, it's the same person. And this is the person who is creating the trust, the person who's putting assets into the trust. So in your situation, if you're creating the trust, you're the grantor. The trustee is the person who owns or has the legal ownership of the property. And then the beneficiary has the beneficial ownership of the property. So you can think of, your interest in your property as, this is the way we describe it in law school, as a bunch of sticks, right? You got a bundle of sticks that are all held together. Each stick represents the rights or the powers you have over your property. So you have the property to sell it, you have the you have the power to sell it, you have the power to make a lien on the property. Maybe if you're in an HOA, you gave up some of that power because you don't have the power to paint it whatever color you want. And so with a trust, what we're doing is we're dividing those sticks into two pieces. So the grantor is the one who has all the sticks. They put it in the trust, they divide it into two pieces. You have the trustee's powers and you have the beneficiary's powers. Now, with a revocable trust, you are the grantor, you are the trustee, and you are the beneficiary. So you took your bundle of sticks, you divided it in two, but it's still on both of your hands. You still have exactly the same powers you had before. You just created a document that says it's separated into two pieces. That way, when you pass away, the owner of the asset is the trust, not you. And that's how we get around probate. And you've divided these powers between different people, and you're going to say, okay, this person is now my successor trustee. After I pass away, they have these rights, and my new beneficiaries are these people, and they have these rights over the property. And so it can be the same person. You can have the same person as your successor trustee and a beneficiary, but it creates that separation between them so that one person doesn't have full control over everything, and kind of creates checks and balances between the trustees and the beneficiaries. And this slide talks about kind of those things that we talked about before with the different kinds of trusts, how we can take a revocable trust for estate planning, and we can incorporate some of these other things that maybe you heard about as being marketed as part of a trust, and incorporate them into the living trust. So we can do dynasty planning, where we can create a trust that's going to last for multiple generations. We can do a special needs provision within the trust. Maybe you have a child who has special needs. We can create a provision in there that's going to create a special trust for them upon your passing, where their share that they would have received is segregated from them so that we're not disqualifying them from their government benefits. We can create substance abuse provisions. We can create education provisions. They have to get certain education. We can stretch the distributions over periods of time. All these different things can be incorporated into an estate planning trust. Not necessarily you have to have, a separate special needs trust. You have to have a separate estate planning trust. You have to have a separate, all these different trusts. You can pretty much incorporate most things into one trust. And then taxes, estate taxes. So right now the federal exemption is 11.7 million per person, which means a married couple technically could pass just over $23 million without there being an estate tax. For most people, that is not an issue. The issue comes in if you live in some of these states, where if you're getting below these limits, there's an estate tax. Most of the estate taxes, they go up to about 16%, which for most of the states, that can be a pretty sizable chunk of money. And so there's certain things that we can do within the trust to minimize the state estate taxes, to be able to get around them so that we're not having to pay the tax man when you pass away. The other type of tax that you have to worry about are inheritance taxes. I have those listed at the bottom there. There's only a handful of states. These are taxes that are paid by the beneficiary when they receive the assets. So if your beneficiary lives in one of these states, they're going to pay a potential estate tax or inheritance tax to the state. It doesn't matter if you live in a different state. So with those ones, you got to be careful with. You may want to tell your kids to get out of one of those states.
John, can I add something here?
Sure.
One of the questions we get a lot is, I'm inheriting some money. Is there any taxes due? Estate taxes are taxed to the estate. So when you receive anything, we're kind of, I think we can most of the time be confident that the taxes, if there were any, were already paid. The inheritance tax, though, is not paid by the estate; it's paid by the recipient. And it doesn't matter where mom and dad lived. It matters where you live as to whether there's an inheritance tax or not. Is that fairly correct?
Correct. Yeah. And before you get too scared, if you live in one of these states with inheritance taxes, a lot of times there's exemptions for, passing to a spouse, passing to children, things like that. So if you keep it in the family, typically you're not paying a whole lot in inheritance taxes. It's if you start trying to give it out to, skipping generations, give it to the grandkids, give it to friends, things like that. That's where you usually get hit with the inheritance tax. So. All right. Don had already mentioned these things. These are other documents that you want along with your trust. An estate plan is not just a trust. You want to have other things. We mentioned before, we do have a trust, but you also want a will. It's called a pour-over will. It's a backup to the trust. So ideally, if we had everything in the name of the trust, we never need the pour-over will. But if for some reason you left something in your own personal name, then we've got the pour-over will that's going to catch that asset. It will have to be probated, but it'll transfer it into the trust after you pass away. So I hear it from clients all the time. They say, I don't need to fund the trust. I have a pour-over will. Well, good luck with probate. You still want to fund your trust so that you're avoiding probate, but we have a pour-over will just in case as a backup. And then we have also got the powers of attorney, the financial and medical side. These kick in if you become incompetent. So if you are, in a coma or for some reason you can't, you have diminished capacity in some way, then we name an agent under the power of attorney who can make decisions on your behalf. That agent does not have power unless you are considered incompetent. So you're not giving up that power unless that situation arises. The alternative to not having a power of attorney is going to court and having you declared incompetent and having a guardian and conservator appointed for you, in which the guardian and conservator has regular updates that they have to give to the court about your condition and about your finances and about your care. It is not a fun situation to go through.
So it's critical on these powers of attorney that they include HIPAA provisions, then, isn't it?
Correct. Yep. So we include HIPAA provisions that release the medical information if someone passes away. I actually had a neighbor. He came to me. His sister had cancer. She was in and out of consciousness. She wasn't really capable of determining her own care. But the family couldn't do anything because she didn't have any of these documents. So they came to me. I drafted some documents for them, just powers of attorney. When she was conscious and she did have capacity, they had her hurry and sign them. And it made a world of difference for that family. They were so grateful about how much more the doctors could actually talk to them, how they could actually interact with the doctors and help her get better care, and all these things. So it is a big deal to be able to have these documents to help make sure that your care is what you want it to be. And along with that, there's what's called the Physician's Directive. It's also called Advanced Healthcare Directive or the Living Will, where you get to decide ahead of time what kind of care you will receive. If you want a DNR, do you not want to receive CPR? Do you not want to be on a ventilator? You get to determine that ahead of time, and then the doctors are bound by that directive in providing care for you. So, and then we've also got declaration of guardians. That's typically put into the will, where you get to decide who gets to be the guardian of your children if they're still minors. The worst situations I've ever had to deal with are those where the parents did not designate guardians for their minor children, and I've seen minor children disappear, quite literally. They go off with some distant relative and the rest of the family never sees them again. And it's really sad. So if you have minor children, you need to have something at least in writing saying, this is who my kids are going to go to.
So John, one of the questions is, if I have a trust, why do I need a will? And that is one of the reasons is to control all the things that the trust can't own. You can't retitle the kids in the name of the trust. I guess you could, but it'd make them unpopular at elementary school. But no, so pets, we can't put that into the trust. The poorer will, the big safety net to catch all the little stuff that we didn't fund in the trust. That's the will's job. Pets and guardianship of minor children and whatever the trust can't control, that there's a need for the will, and both of them should work hand in hand. But as a general rule, we want assets titled to the name of the trust, or at least so that the trust can control it, and then the will picks up all of the little stuff that the trust can't control.
Yeah, and you'd be surprised at how many times I've had to use a pour over will just to catch a piece of property, or they inherited something from their parents they weren't planning on, and they just forgot to get it transferred into the name of the trust. It was left in their parents' estate for a while. And we had to use the pour over will to get those things transferred into the trust. So it's always good to have that safety net. In fact, in some states, it can actually be considered attorney malpractice not to do a pour over will with a trust. Because of the number of times it solves problems. So, okay. Schedule of gifts. We talked about this before, that personal property memorandum or memorandum of gifts or things where you can list specific personal items and you can list who you want it to go to. You may not think this is a big deal. Most of the fights I deal with are over the personal items. I'm sorry. I can take $1, and if you have 4 kids, I can go into the bank, divide it into quarters, and give each of your kid a quarter. I cannot take your wedding ring and divide it into 4 and give the kid each 4, each other one little piece of it. And so when the families fight, that's where they fight. I've had families fight over Parcheesi boards. I've had families fight over a trash can. You got to understand this trash can. It was stainless steel. It had a little button that you flipped, and the top of it flipped up like this. It was like the DeLorean of trash cans, except for it couldn't travel through time. And they all fought over this thing. You would be surprised. So if you can go and you can specify, okay, Mary gets the shotgun and Johnny gets the trouble sewing machine. Then if your kids want to trade after you're gone, fine. If they're mad about it, fine. They can go jump up and down on your grade as much as they want to be mad about it. But the kid didn't take it from the other kid, and they're not mad at each other. I can't tell you how many times I've seen families split apart just simply because of these personal items, or the house
Some
sits
of these some
vacant
of
for a
these
long
things are
time.
really hard to decide, but it's going
Yeah,
to be 10 times harder once you're gone for the kids to fight it out.
yeah. There are ways in which we can make it fun. I did this in my own family where we did a family auction. Everybody got Monopoly money, and we just started, auctioning off everything in the house, and it worked great. Everybody was happy because that's a way of assigning sentimental value to an item. It may not have a lot of value monetarily, but that sentimental value is hard to figure out. And so, we did a family auction within my own family. We've done it twice, and it works out great. So. All right. Final instructions. That's just, what do you want your funeral to look like? Do you want to be cremated? Do you want to be buried? With these types of things, the final instructions, make sure that your family knows what you want to do ahead of time. I've had I had a client that we wrote it into his documents that he wanted to be donated to science. He wanted to go to a medical school so that he could be carved up and all these cool things. He thought it was really cool. Um, Passed away, didn't bother actually telling anybody in his family. The family took him to the morgue or to the mortuary, had him embalmed, had him buried, and then they pull out the will and the documents and the trust and start reading them. It's too late. Sorry, he's not getting donated to science. So, final instructions, even though you may write it down, it's still kind of up to the family to actually honor those things, and you want to actually let them know ahead of time so they're actually honored.
John, can I make a comment here? The biggest fights that I've seen and the wounds that don't go away is when they don't have a medical power of attorney put together.
Yeah.
And 4 kids go, yeah, it's time to unplug dad. And one of them's going, no, you can't kill my dad. And those wounds don't go away over time. In fact, they tend to fester, and that splits families apart. These are simple documents. They're not easy decisions to make, but it's a whole bunch easier while mom and dad are making the decisions and saying, here's what I want. Anyway, just a little comment. Thank you for
Yeah.
entertaining that.
Well, and I've also seen family or clients where they the family, they couldn't come to a decision. It took them a while to come to a decision to finally unplug dad, and they unplugged dad, and he'd actually stabilized, and he was just in a vegetative state for years, simply because it took them a while to actually make those decisions.
And maybe it cost the estate a whole bunch of money to keep dad alive when
Yeah, I mean,
maybe he really didn't want it to be that way.
yeah.
Yeah.
So,
Okay.
all right. So this one's kind of looking ahead at more of the speculative. So there's a lot of talk about what's going to change within estate planning. There's a lot of different proposals in Congress as to how things are going to be taxed, how things are going to be distributed, and changes that are potential to estate planning. And you need to understand these, because if you do planning now, you could actually get ahead of some of these changes that are going to, they do look like they're going to be implemented because they can all be done through reconciliation. And as we saw in the last reconciliation bill, there were no input from the other side. It was exactly as it was proposed. So with the proposals that we have right now, they're looking at dropping the federal exemption from the 11.7 million to 3.5 million with a limit on gifts of $1 million during your lifetime. This is going to have a huge effect on estates, especially the gift changes, because before we could either gift 11.7 million or we could pass 11.7 million through an inheritance. The change to 3.5 with the 1 million gift limit, it's going to hit a lot more estates. The step up in basis is going to be gone. That one is a huge hit, not just to the wealthy, that's a huge hit just to middle class people. It's it's going to hit your kids pretty bad, especially with the changes to the capital gains rate. You know, you could have a family that all they have is maybe personal residence and a life insurance policy, and they're going to be paying 40% of their estate in taxes. It's pretty big. And then another thing is the change to the GST. So if you're looking at doing a multiple generation trust, that's going to keep going on for multiple generations. With the change to the GST or the generation skipping tax, it's going to kill those. If any trust goes longer than 50 years under the new proposals, it's going to get hit with the generation skipping tax, and you're going to be paying a ton of taxes. We can set those up now, and everything that's set up before the law is passed gets grandfathered in. So there's, you know, we want to be doing that ahead of time now if that's something you want to do. And then the most extreme of them is what's called a deemed disposition. If anybody's familiar with Canadian law, they would be familiar with this deemed disposition. Basically, it states that when a person passes away, all of their capital assets will have been deemed to have been disposed when the person passes away. So even if you don't sell the property, even if you don't sell the stocks, it will have been deemed to have been disposed and you owe the capital gains. And then you combine that with the changes in the capital gains rate. Again, you're looking at a lot of people are going to be looking at a 40% hit for taxes. So those are some things that are in proposals right now. All of the proposals, as I've read them, all either say anything done before the passage of the law or was done before the beginning of the tax year, which January 1st, are grandfathered in. And so some of these provisions would actually not apply to those trusts that were done before. So this is something you want to, if at all, consider doing now and not waiting until the laws change. Okay, I have one more story. I don't know if you want to do a few questions right now, and then I'll kind of tell my little story here.
We've got a ton of questions, so let's. Okay. All right. So, what's the best way to set up a trust for an indexed universal life policy? Should the trust be the owner if one of the trustees is the insured, and the beneficiary? Who should? How do we set up an indexed universal life?
So with an indexed universal life policy, depending on if you have a taxable estate, so we're talking about, you know, over the 23 million, if you're married, 11.7 million if you're single. If you do have a taxable estate, that's going to look different than if you don't have a taxable estate. If you don't have a taxable estate, you just set up the indexed universal life in your own name. You make your contributions to it, and then you can just list the trust as a beneficiary on that policy. It's really simple. If you do have a taxable estate, then we can set up what's called an irrevocable life insurance trust. And then there's gift taxes that are applied to it. You would want to talk to an attorney about that to be able to get that set up.
And that's a form of an irrevocable life or irrevocable trust, and that's not something you want to do yourself. You want a good
No.
professional working with you on a IUL policy inside of an insurance policy inside of a trust. Yep. Okay.
Yeah.
So what's the best way to set up a trust? Oh, wait. I have 3 investment properties, 2 paid off rental properties, 1 mortgage. What do you recommend?
Uh,
Meet with an attorney and see what we got and what state it's in. And
yeah. I mean, what state are you in? I'd probably say, I mean, a knee-jerk reaction, just a revocable trust is going to work just fine for you. It doesn't, based off of that, I don't think you have a taxable estate, so I don't think we're getting into the irrevocable side of things. And so just a simple revocable living trust to own what you own in your personal name. Should be
the
able to,
investment properties may be in LLCs that are then owned by the trust. Then,
right? Correct.
Okay. There are investor loans now called cash flow loans or debt service loans that are allowed to close in the name. Oh, it looks like that's not a question. Okay. Should I transfer my 401k or Roth IRA into a family trust and keep them under the name? Okay. Can you transfer an IRA or a 401k into a revocable trust?
So the answer is yes, you could, but you don't want to. You're going to get hit with a pretty bad tax bill if you transfer your trust while you're alive, or you transfer your IRA or 401k into the name of the trust while you're alive. But what you can do is you can have a trust as the beneficiary of those IRAs and 401ks. That way it gets distributed to the trust. If you have someone who's smart as your trustee and has a good head, then what they can do is they can stretch that IRA or 401k for 10 years after you pass away, keep it going, and then pull the money out of that IRA or 401k and distribute it to your beneficiaries.
Right. The 401k and the IRA already are trusts.
Right, they are a trust.
There's their benefit, and the standard rule is a trust can't own a trust, although a trust could be a beneficiary of a trust.
Right.
Now, there's exceptions to every rule, but that's how my simple little brain remembers it. So, okay, if I set up a trust and after years I changed my mind, can I modify it?
With a revocable trust, yes. With an irrevocable trust, no. That's why we typically will use a revocable trust for most situations, because you always have that ability to modify it later on.
Okay. What do you have a recommendation of available Northern California attorneys or somebody to establish an S corporation and multiple properties? You guys at Anderson work in all 50 states, do you not?
We do. We have actually a few attorneys who are licensed in California specifically. And so we can work with them and that's right up our alley to get those types of things set up as corporations, or even an LLC taxed as an S corporation, which may even be better. And so, yeah, that's something we can help with.
And how you can always contact us at Protect Wealth, and we will send a referral over to Anderson, or attend the summit and contact Anderson that way. We'd like to. In fact, almost every day I'll sit down with somebody on the hotline and get a summary of what they want and send that over to Anderson and say, here's a little summary. I carbon you on the email so that you see it. And after that, what you do with the attorneys is attorney-client privilege, and I don't want to be part of that. That's for you guys to figure out. Okay. If a husband and wife still married, but wife wants to do an estate planning individually to pass on to their children, what type of planning would be best? So it sounds like husband and wife, they're married, but only the wife wants to do an estate plan.
Just a revocable trust, it would be an individual trust as opposed to a joint trust. But yeah, I've done those before, and you would have to have assets that are just the wife's that she would be passing on. So if your wife just wants to do it and you all have joint assets, you still may need to sign some of the documents. She may take care of it for you, like most wives do for their husbands. But yeah, it depends on your situation.
What's the difference between a living trust and a land trust? Can both be used to protect assets? And if so, how?
Yeah, so a land trust is just a revocable trust. Like I said, there's only two types of trust, but it's written in a specific way as to hold property, hold land. They're usually used to transfer property that may have a mortgage on it, or to hide the transfer of ownership from public records. Whereas with a living trust, typically we're talking about something that's written for estate planning purposes. So it's written to pass assets from one generation to the next. Again, it's typically a revocable trust. Technically, I could write a trust that has both land trust and revocable trust provisions in it, but the type of ownership or the type of purposes that you're using them for are usually pretty different. If you've got rental property, you might be putting it into a land trust that then has the LLC as the beneficiary, and then under that LLC, you might have like a limited partnership or a holding company that then goes into the living trust. So the where it kind of fits in your structure is going to look differently, and it's written for those different purposes. So,
Okay. Adriana is asking, does transferring an account to a trust generate any taxes to be paid? So if you own an asset like a bank account or a brokerage account, you're transferring it into a trust that you own, is there a taxable event?
so for the most part, if we're just dealing with revocable trust, no, there is no, it's not a taxable event. In fact, with a revocable trust, that is what we call a grantor trust under the IRS code. The IRS doesn't even want to know this trust exists. They don't care. And so when you transfer a asset into the trust, say you're transferring your LLC or your entity into the trust, it's generating income. You still file your taxes exactly the same. If anybody wants to know the tax ID number for your trust, it is your social security number. And so it's a non-event for taxes.
Okay, good. Now, real estate could be different. Real estate could be property tax reassessment if you don't do it right. There could be a real estate transfer fee, Florida, Pennsylvania. But if you're doing this right, most of the time Anderson is really good about avoiding all even real estate transfer fees.
The only
No.
state where you would have a real estate transfer fee transferring property into a trust is New Jersey. New Jersey is the only state that actually imposes a fee for transferring into a living trust for estate tax purposes. Every other state, there's ways of getting, they allow for an exemption.
But if you screw that up, California,
Yeah.
and you transfer it and don't do the preliminary change of ownership form, and you lose your Prop 13 rights, there's certainly ways to screw this up. That's why
That's correct.
funding the trust is it's really important that you have somebody that's helpful and that knows the game. All right. If there are multiple real estate properties and bank accounts, do all of them have to be in the same trust?
Yeah, so typically you're just going to have one trust that you'll use for your estate planning. The idea of the trust is it's going to own any assets that you would normally see your own name in that place as owner. So, if you've got, real estate, it's all in a bunch of different like LLCs. If you would have normally seen your name on there as the owner, we want the trust on there as the owner. Separating it out into multiple trusts isn't really going to do anything for you. The living trust for estate planning is not an asset protection tool. It's not going to provide you any protection. That's why you use limited partnerships. That's why you use LLCs. That's why you use corporations. Those are your asset protection tools. A living trust for estate planning is not your asset protection tool. So you don't need multiples of them.
Okay, if a person has a living trust and they pass away, does it need to be published in a local newspaper to give notice?
No, that's only a requirement of probate court.
And you remember the whole purpose of, you remember probate, it's an old English law. And it was, hear ye, John has died, and so if you have claims against the estate, bring them forward. And that's where this all started, is the probate thing came from. But if everything is a matter of private record, it's nothing, then if then we avoid the probate process and the notice to the newspapers, because we're avoiding the whole process. It's a good question, but okay, for bank accounts, wouldn't just a beneficiary be enough? I think you covered that.
Yeah, so I mean, you can, but as soon as you pass away, that person gets that bank account, and there's no obligation for them to, take care of taxes, to take care of any expenses that may to be taken care of. Medical expenses. A lot of times after someone passes away, there's still medical expenses coming in, and those can follow the account holder. So if you have your beneficiary just taking over your account and they're not taking care of those expenses, the creditor can come back later and actually go after those accounts.
Okay, question about, can you go over the benefits, restrictions, pitfalls of a charitable remainder trust? I'm going to say, call us at the hotline tomorrow, and I'll answer that one privately. I've written chapters and books on charitable remainder trust, but it's a little bit more complicated than I think we want to handle here. John, do you agree with that?
Yeah, charitable remainder trusts are dangerous, to put it frankly. You've got to make sure you're dotting your T's and crossing your I's, right? Otherwise, you're going to get in trouble with the IRS pretty easily. And it's not just a little bit of trouble. We're talking about tax fraud and criminal charges. So it's not
Correct.
something to be taken lightly.
Mildred, how do I fund a trust? And John, I'm going to say I'll spend almost 2 hours at the 3-day summit talking about funding each one of the assets. How do we fund a bank account? How do we fund real estate? But real quick, what's the process of funding a trust, putting the assets into the trust?
Yeah. So your main assets are real estate, personal held real estate. It's going to need a new deed that transfers it from your name into the name of the trust. With bank accounts, brokerage accounts, those types of things, you will use what's called a certification of trust, which usually is drafted with the trust. You'll take that into the bank and say, I need to change the name on the account. Either they'll change the name on the account or they'll set up the trust as a payable on death beneficiary. Either way works. Just depends on bank policy. For businesses that you own, it's pretty simple. It's just an assignment of interest document. You can get a form pretty easily that transfers it from your name into the name of the trust. Securities like stocks, bonds, those types of things, if you actually have those in your personal name, not in a brokerage account, then you would have to have those reissued into the name of the trust.
Anything with the title, it ought to be retitled.
Right. So the whole idea of probate is a dead person can't sign their own name. And so the court's appointing someone to sign on behalf of the deceased person. So with the trust, if the trust is the owner, the trustee always signs on behalf of the asset, and you're the trustee while you're alive. When you pass away, you've already appointed a successor who automatically can sign on behalf of that asset.
Bottom line, if there's clear title to an asset when you pass away, then it avoids probate. The purpose of probate is to figure out who owns your stuff if there's not clear title.
Yep.
Is that did I screw that up too bad? I haven't been through law school, but I think I get that one.
Yeah, it's
Simplified version.
simplified version of it. Yeah.
Okay. Thank you. Will having assets in a trust instead of your own name affect your ability to get financing?
Potentially, yes. But what you can do is you can transfer the asset from your name from the trust back into your own name. As soon as it closes, you can again immediately transfer it back into the trust because again, they can't do anything to stop you under federal law. So it just depends on your lender. Some lenders are getting better at allowing you to like refinance your personal home if it's in the trust. And so you may look around at different lenders to see maybe if there's one that would allow that. If not, then like I said, you can just transfer it into your name. As soon as it closes, put it right back into the trust.
And Clint is going to spend a lot of time at the summit talking about how to get financing, especially on real estate, and how not to screw this up. Okay, question. What states are you licensed to practice law and prepare trusts for? And I assume he means not just you, but Anderson Business Advisors.
So we have attorneys licensed all over the U.S. I don't even remember all of them. And we prepare trust documents or estate planning documents for all 50 states. So we're pretty well versed in all the different states. Even myself, if you lived in Florida, I could tell you the difference between Florida and Tennessee versus Texas versus New York. I'm pretty familiar with all the laws. Plus, most of them are fairly uniform if you go from state to state, because most of them have adopted what's called a uniform trust code. And so they're actually pretty similar. There's only a few changes from state to state. So we prepare in all 50 states, and we're pretty familiar with them.
Okay, Paul is asking, and by the way, we have about 5 minutes left, and then we need to let John go. We're not going to get to all the questions. I'm sorry, we're doing our best. Paul is asking, how do you handle a primary residence within a living trust?
So you treat it as if it's your own personal home still. So it still qualifies for homestead protections. If you're in a state with homestead protections, still qualifies for your tax deductions for a personal residence. You still get, your 250,000 capital gains exemption for that. If you sell the property, the only difference is instead of you signing the documents personally, you're signing the documents as trustee. So you just deed the property into the name of the trust and keep living your life exactly the same as you have before. So,
okay. Ricky is saying, are Anderson's living trusts that he did 10 years ago, are they grandfathered in before Biden's tax proposals? Ricky, there were some major changes to the law in 2005 and in 2012, especially what that dealt with HIPAA provisions and the estate tax laws. Any trust that was prepared before that probably ought to be restated, and I think it's a good idea. John, tell me if I'm right. Is to have somebody look at your trust once in a while. How often do you have? Would you recommend that the trust be restated?
it really just depends on the circumstances. So, I have clients. 5 to 10 years is pretty typical to either amend or restate a trust for most people. But I've also dealt with, people who wrote their trust back in the 1970s, and it was mostly okay. We could work with it after they passed away. And so is there a set time? No, most of the time it's more based off of changes in your life, big life events. Do you have kids? Are your kids now grown up? Maybe you created the trust when they were younger. Do you have grandkids now? Maybe you want to put in some provisions for them. Those types of things are usually when I see or see a need for changes or updates to the trust. Now, the changes in the tax code, those are changing quite a bit. If you have an older trust that's maybe what we call an A/B split trust, you may want to consider doing a restatement so that you don't have to do that split anymore because it's not needed as much. And that was done in 2012, I believe. So if you have a trust that's older than that, maybe we would want to restate it. But other than major life changes, most of the time you're not really going to have to change the trust.
Yeah, good. If there's a major change in assets or life, there's a divorce, there's a death, there's remarriage. Kids do stupid things, and maybe they have bad marriages, and it's the life changes, I think, more than the timing. I agree with that. Okay, so John, there's no way we can get to all the questions. We're going to refer people back. Remember that there's a Q&A every Thursday with me at around 11:30 Mountain Time. You're welcome to call back in at that time. I'm going to refer a lot of this back to the 3-day summit, where it's really designed for 3 days to go extensively about trusts. And between Clint and I and Scott Estel and the rest of the attorneys that are there, I think we answer most of the questions. So you've got a slide on your screen about planning done right. Tell us what that, because I'm wondering what that little sign's all about.
So, right, all we have, we owe to others, right? So this is the sign that actually was in front of my grandparents' dairy farm. So my grandparents had a dairy farm in Meridian, Idaho. It wasn't a big farm, and they got by. They weren't super wealthy. But as my grandfather got older, he kept working on the farm well into his 80s. But eventually, his health was declining, and he had to do something with the farm. None of the kids, there are 6 kids, none of them wanted to keep the farm going. So he decided to sell part of the farm. This was in about 2006. If you know anything about Meridian, Idaho, it exploded in growth. And so he sold part of his farm and made a pretty decent amount of money, a few $1 million. At that time, though, the estate tax was the exemption was much lower. And he was going to owe a fairly large chunk of money in taxes when he passed away. So despite his better judgment, he did go and talk to a lawyer about it and get an estate plan. So there were some suggestions that were made to him to help him reduce that estate tax. One of those suggestions was to make gifts. He could gift about so my grandparents, between the two of them, they could gift about a little bit less than $25,000 to an individual and not have it count against their estate tax. Well, my grandparents, they have 6 kids. Their kids have a lot of kids. There's a lot of grandkids. So they were able to make 2 gifts, one in December, one in January, because it's a different tax year, 25,000 once, 25,000 again, and basically deplete the entire estate down to the actual exemption amount. So there's no estate taxes owed. So that means I was one of the beneficiaries of those gifts. And so I got $25,000 to kind of do whatever I wanted with. And then the other $25,000 was set aside for the purchase of a home. And, I took my $25,000 and I didn't go to Vegas. I was a good boy. I was just in college at the time, and I used that $25,000 to pay for my law school, so that I wouldn't have student debts. If you look, and then I used the other $25,000 to purchase a home, and it was at the very bottom of the market at that time. If you look at that $50,000 that I got, it was a little less than 15,000 or 15 years ago, and you look at how much that value has increased, conservatively, based off of my estimates, it's probably at least $500,000 in added value to my life. And it's just $50,000 that I got when I was younger. So when you do estate planning right, it can have a huge effect, especially on those next generations, to help them get ahead and be able to achieve things that maybe you weren't able to do during your lifetime. I've got several kids. I live in a really good neighborhood. I actually live just down the street from Dawn. And it's definitely had a major effect on my life, and during my lifetime will probably amount to millions of dollars in added value to my life. And so even just small gifts that you can make, and making those done right can have a very significant effect down the line. So,
John, thank you for being on. So Kendall, if people want more information and want to meet the people with Anderson, will you put in their access? How would they go about registering for one of the upcoming summits and hearing more? Or contacting us? There we go. Protect Wealth, protectwealth.com/live events. That you'll see that. And then, Kendall, would you also put in our phone number? If they have questions, we can always refer them over to Anderson, and that way, our Anderson treats all of their students really well. But when they're coming from us, it's I like to think we have a special place in your heart. I don't know if that's true or not, but
yeah, I'm always worried Don's just going to drive down the street and come after me if I don't treat his clients well. So,
well, thank you all for being on tonight. I know we did not come close to answering all your questions, but we appreciate you being here. And John, we appreciate your time and your tremendous expertise, and those of all the attorneys that back you up in your department. Thank you for being on.
yeah, thanks for having me.
Okay, and everyone, don't leave your family in a mess. Make sure that we take care of these things. They're easy documents to fill out. They're easy when you're working with the right people, and they're going to ask you some tough questions, but it's a whole bunch easier now than it is later. So we appreciate your time. We appreciate you being on, John. Thank you, and everyone have a great night. Good night.